Hi, everyone. Just in case you didn't hear me before, we are just about ready to get started. We're going to give everybody just a few more minutes to log in and access the platform, and we'll be getting started momentarily. And until then, please just sit tight. Okay, so hello and welcome to everyone. My name is James York, and I'm very happy to present you with this webinar with some excellent content from an attorney based in New York, covering all things patent and trademark related in regards to U.S. filings for global entrepreneurs, which are you. Before we get started, I just want to go through a little bit of housekeeping with everybody. So if you haven't yet been on one of these webinars, please notice to the right of your screen, there should be a chat box. And if everybody can hear me and see the slide that is up on the screen at the moment, please type yes into the chat box so we know that everything is working. Perfect. Thank you, Mari. Alexei, David, Raivo, Tarmo, Flavia, Alvar, etc. Beautiful. Thank you very much, everybody. What I would like to then call your attention to is if you scroll down on this page, underneath the slides, you should see an area where you can enter your questions. I will ask everyone to please, throughout the course of the session, please enter your questions here in this space underneath the slides rather than the chat box, so that when we get to the dedicated Q&A section at the end of this presentation, we'll be able to bookmark where each of your questions have been answered, so that when you automatically get the replay of this webinar, you will be able to go back and refer to exactly the questions that you want answered. And so with that, please allow me to introduce myself. So my name is James York, and for those of you who haven't met me yet, I am normally based in New York, working from the office of the Estonian Consulate General, about 2 blocks up from the UN. However, I have been working, quote unquote, remotely from HQ here in Estonia since mid-June, and I will be here at least through the end of the year. So if anybody on this webinar would like to set a time to speak with me in person while we're here, assuming the numbers allow it, or would just like to schedule a video call, please feel free to reach out to me. I'm Director of U.S. Business and Innovation. I act in the capacity of a trade advisor to the consulate, and I am here to help you, Estonian businesses, who are looking at the American market, and I am happy to provide you with a wealth of resources as well as feedback and conversations on any topic related to the U.S. market that might be of help to you. So please do reach out. If we haven't yet spoken or connected, I would love to connect with you. Please feel free to reach me on this email, and then I can share with you a calendar link and we can set up a time to meet. The topic of today's webinar, of course, is fundamentals of U.S. patents and trademarks for global entrepreneurs. And I have for you today an absolute expert in the field, based in New York, David Boag, attorney at law, And with that, David, I will allow you to share your own background so that I'm not missing anything. But for everybody who is listening, David really knows his stuff, and I encourage you, in addition to getting the replay that you will get, do take notes, because having seen the slides, there's a lot of really useful and actionable information to be found over the next hour. So with that, David, the floor is yours. And I believe you are muted.
And thanks for all your hard work in setting this up and for
My
having
pleasure.
me. Thanks to everyone for being here today. And of course, thanks to Enterprise Estonia and the European Union Regional Development Fund for their support in making all this possible. So I am a patent and trademark attorney in New York City. I've been doing this since 2001 or so. I started my own practice about 7 or 8 years ago, and we focus on all things intellectual property, patents, trademarks, copyrights. We help people get applications through the various offices. We do litigation. We send cease and desist letters. We help people with doing their due diligence, all sorts of things like that. So our core, if we have a core, we do work with a lot of entrepreneurs and smaller businesses. My background is in computer science, so I have a soft spot for all things technology and software. So we do help a lot of entrepreneurs with things like that. So today, just as a very quick overview, we're going to take a look at, we're going to talk about patents, and we're going to talk about trademarks with a little bit of a US focus, basically the fundamentals, some strategies and things like that. And then within each of those, some international considerations for cross-border filings and making sure you're able to economically perfect your rights in different countries around the world. So to get started, let's take a step back and think, like, why is any of this important? Why are you guys here? Why are you interested in this? Why do people care about IP generally? And there's basically two sides to this coin. The one side is that you want to be able to protect yourself from other people copying you. It's a pretty straightforward and simple one. You want to be able to even monetize your ideas without building a product through licensing. The other side of this is you want to avoid other people's patent and trademark rights. That can be very painful for a new business to run into a cease and desist or even an infringement litigation early on. And it's often very avoidable. And the damages there, even just the cost of defending it, can be significant. So the two sides to this, offensive and defensive. Here's some worldwide statistics that kind of drive that point home. 2018, this comes from WIPO, which is the World IP Organization based in Switzerland. 2018 is the last year I think they published, or the last year they have accurate statistics. I think we're still waiting for the next year. But you can see that patents are up year over year. We're up to 3.3 million patent applications filed worldwide that year. Utility models, which are basically an abbreviated type of patent, still over 2 million. Trademarks, almost 14.5 million trademark applications filed worldwide in 2018. And even design patents or industrial designs, well over 1 million of those filed worldwide that year. So it's big business. There's a lot of activity. The economic value of just the patent licensing market, I've seen estimates of it being close to $200 billion annually. And the trademark licensing market, when you think of all the different, superheroes and toys and everything else, it goes into close to $300 billion annually. So there's a ton of activity and money in this. There's basically 3 buckets of intellectual property. And when we talk about that, the first one is a patent. And here's a generic US patent with a claim shown there. Patents, as we all know, protect inventions. A patent gives you the right to stop someone from practicing an invention. It doesn't necessarily give you the right to actually practice the invention, which is an interesting quirk, just the right to stop someone else. And the criteria there are novelty, has to be new, can't be obvious, and has to be eligible subject matter, which is something we'll talk about in a minute. Trademarks, a couple of my favorite trademarks over there on the right. Trademarks protect brand names. They are an indicator of source. A little bit more technical of a definition is a symbol that identifies and distinguishes the source of goods from one party to the next. And we can all think of tons of those that do that. They come in different shapes, words, logos, sounds, smells, even color schemes, product packaging. Those are all eligible for trademark protection. The criteria is a little different. Once you get away from words and logos, it becomes a little bit more difficult, but those are still available if the public recognizes your brand. Copyrights, we all know copyright protects creative expression, even source code to a certain extent, recorded music, all things like that. Copyright is the exclusive right of an author to exploit their work. That means making copies. It means publicly performing the work, preparing derivative works, things like that. We're not going to talk too much about copyright today just because of time considerations, but it's certainly an avenue that's worth looking into if you're developing software, for example. You can get very powerful protection. There's basically two main types of patent. It varies from country to country with some nuance, but the basic variations are the utility patent. And this is like the granddaddy of them all. This is that right to preclude others from making it. You get a 20-year term in the United States and most countries around the world. 20 years, I put the asterisk there. It's 20 years from your earliest filing date. So if you're filing, a chain of applications in one family, for example, that 20-year term goes back to that earliest filing date. And it's about, in the United States, it varies depending on the technology and how busy the examiners are. If you can get it through in about 2 years, that's pretty good. It tends to take a little bit longer. There's mechanisms if you want to pay an extra fee that varies from, in the United States, $1,000 to $4,000. You can go to the front of the line and get it through in a year. So the more economically significant inventions, I guess you could say, that's the theory, percolate to the top. Design patents are, I think, an often overlooked tool in the IP arsenal. They protect ornamentation. This is the look and feel of a device or whatever. Interesting examples, like a smartphone, for example. The shape of an iPhone is certainly protected by a design patent. Separate utility patents protect the function, though. Here, with a design patent, it has to be novel. It can't be obvious still. And it also has to be not functional. It can't be primarily driven by function. That's an important consideration there. 15 years from issuance is the term for a design patent. It's a little bit different than a utility patent because it's measured by the date that it issues. And the damages in the United States, at least, are the infringer's profits, which is very different from the way the way damages are measured for a utility patent. And if you're a small innovator with minimal sales, it's a very powerful tool to go after a copycat. And some examples are shoe designs, smartphones. User interfaces are an interesting quirk, an interesting tweak on design patents. Icons and user interfaces too, possible. Many of you have probably heard about provisional applications. That is a species of application, not really a separate type of patent. These are a tool that we use to efficiently and quickly file patent applications and secure a filing date. They tend to be less costly, at least up front. There's no claims, so you don't have to go through the expense of having an attorney draft those claims. They're never examined. They expire in a year in the United States, but they're useful for getting you a filing date for what's disclosed in that provisional application. So it still has to be reasonably complete. You can't just do the provisional application to secure your filing date and then come back in a year. But as long as you have a reasonably coherent disclosure in there that's complete and hits all the bullet points for the invention, the fact that it's less formal isn't going to be a problem. You can clean that up later on. There are three main requirements for getting a patent. These are pretty universal. It has to be new, novelty. No one can have created the same invention before you and made it public. for a one-to-one exact correspondence with the prior art, prior patents and publications. Non-obviousness means that the prior art doesn't disclose exactly what your invention is, but it's close and there's a gap. And the question is that gap between the prior art and your invention, how inventive is that? And would it be obvious for a person of ordinary skill in the field to bridge that gap? And I put the pencil up there because a good way to think about it is we've got a pencil with an eraser at the end. So assume we had a pencil previously and we had an eraser, and some guy or woman came to the patent office one day and said, I created this eraser at the end of a pencil. Is that obvious? Well, we already had the pencil, we already had the eraser, and it seems likely that someone would want to be able to erase what they wrote with the pencil. So putting the two together, that's probably obvious. And examiners come back with obviousness rejections. It's typically a combination of multiple references that they'll come back with. They'll say, well, if you look at this patent and you put the two together, hypothetically, it's obvious. Very, very common issue to come up in. And then eligible subject matter, we'll talk about right now. So patent eligibility is a very topical issue when it comes to technology. And when it comes to things like software and mobile apps and anything that involves an invention that's practiced on a computer of some sort. Because the Patent Act says that, well, you can get a patent on any new and useful process or machine or manufacture or composition, and you can get a patent on any improvement of any of those. And the Supreme Court has said, well, what we understand this to mean is everything under the sun created by man is patentable. And they actually did use that gender-specific pronoun there. It was in 1980. So, but what the carve-outs here, the corollary to that is you cannot patent a law of nature. That makes sense, right? You can't patent a physical phenomenon because you didn't really invent those, but you also can't patent an abstract idea. Abstract ideas is what come up a lot with 101. This is the section of the Patent Act. When you talk about patent eligibility, abstract ideas are implicated because there's often software or an algorithm or something like that. So if we look on that bottom left box, here's some examples of what courts and the patent office have found to be algorithms, fundamental economic practices, methods of organizing human activity. Think about a game or a dance or something like that. An idea itself, mathematical formulas. I'll add to this list signal processing, data processing, things like that all tend to be in that bucket. And there's no definition in the statute for what an abstract idea is. The Patent Act doesn't actually talk about abstract ideas. This is a judicial creation. But we know from experience and we know from by example, and there's some really good examples in that Patent Office. I'll actually put a link in these materials. I didn't put it in this slide, but there's an excellent section on the United States Patent Office's website that really walks through tons and tons of examples of what has been found to be abstract before. So it helps you narrow what you're doing and asking for. So when a patent examiner gets an abstract idea in a claim, they evaluate the claim and they say, okay, wait, this seems like there's an abstract idea here. So the next step in that process is they look at the claim and say, is there something significantly more than the abstract idea itself? Because we're not going to give you a patent on just the abstract idea, but the implementation of it, the application of it, maybe there's something there that's patentable. The underlying premise to all of this is at the bottom of the slide there. The basic tools of scientific and technological work are never patentable. That's what we're trying to avoid here, or at least what the law is trying to avoid. If you think about a particular type of data structure search algorithm, for example, if that had been patentable 20 years ago, think of all the innovation that would have been lost because of that. But an application of that to a particular use, possibly patentable. But very, very fuzzy and confusing the law, but it's something that we all have to deal with in modern times. Let's take a look at what you can do globally with your invention. So IP rights are all territorial, country by country. The rights in one country don't necessarily apply to the other. So we've got two principal routes to getting international patent coverage. The first method is what they call the Paris Convention. And this is an ancient, goes back to 1883. Most countries in the world are signatories to this. What it basically does, the Paris Convention, it says that if I file an application in, for example, the United States, and within 12 months, I go to Estonia and file a patent application there, I can claim my United States filing date as my Estonian filing date. And that can be critically important because of disclosure deadlines and prior art and all sorts of things. It's actually pretty critical to the patent process that we're able to do that. So we don't have to file in 47 countries all at once. You can take the 12 months and figure it out. It provides that right of priority, and it ensures, this is the other fundamental piece of this, all applicants are created equal in the eyes of national patent law. So there's no discrimination between an Estonia, if a United States patent applicant comes to Estonia, he is afforded the exact same rights as would be an Estonian applicant, and vice versa. So this is pretty fundamental to the world IP process. The second one, a slightly more recent, and recent meaning like the last 40 years, is the PCT. And this is the Patent Cooperation Treaty. It's administered by WIPO. WIPO acts as a central clearinghouse, so you get a single application with effect in multiple states. A single application, though, not a patent. So it simplifies the procedure, it reduces the cost, and it gives you the ability to jump into multiple countries very easily. The actual granting of the patent at the end of the process is still controlled by individual countries in what they call the national phase, and we'll talk about some of the specifics of that in a moment. But at least the first step is all centralized through WIPO. Method 2.5 is we have these regional patent organizations that aren't worldwide, but we all know the EPO. The EPO provides a pretty wide net for patent protection in Europe, so much so that it's not actually even coextensive with the European Union. This is independent of the EU, so it'll survive Brexit. But you get a lot of countries when you file an EPO. It's expensive, but you get a lot of countries for one application. And then there's a couple of others in different areas of the world. Eurasian Patent Organization, there's a couple in Africa that can provide kind of a one-stop shop. This is, I put this in not so much to talk through it right now, but I wanted to at least put up an explanation of how these two work, especially the PCT, because you can see here up top, the Paris Convention is pretty simple. It's you file, 12 months later, you file internationally, and that's pretty much it. The PCT has got a lot of intermediate steps, and it's a longer process, certainly more complex. And let's talk about what the differences really are between the two. So with the PCT, the pros and cons of going this PCT route. Why, if I've got an invention, I'm in Estonia, I'm in the United States, I'm thinking about protecting it internationally, and I've got funding, because this is self-funding a PCT is an expensive endeavor, but what are the pros and cons of doing it this way instead of going country by country with the Paris Accord? So the pros are that you have a single application in about 117 countries, plus or minus. All the formalities like search, preliminary review, reporting, and publication are all standardized through WIPO. You get a search report done by WIPO. That search report is passed along to the national agencies. It's actually quite streamlined. It simplifies the international process. It ultimately makes it more economical if you're filing in a lot of countries. It's expensive, but on a country by country basis, it tends to be cheaper than Paris if you're filing in a lot of countries. It's a longer duration generally, but one of the benefits is you don't go into the national phase in each country for about 30 months. So you have a lot of time to consider what countries are important, what countries is my invention marketable in. You might think that one market's going to be great at the beginning, turns out not to be. Well, this lets you spend a little time thinking about it before you jump in and make that expense in each country. The cons here, the high filing fees, it's complex, definitely need some professional help on this one. And it takes longer ultimately to get a patent because of that national phase 30 months. The Paris Accord, on the other hand, gives you a very broad set of rights. A 12-month priority window, it lets you get a patent quickly. It gives you time to develop your portfolio very quickly. You don't have to wait like you do with the PCT. It's comparatively simple. There's very few technical requirements. If I file an application, in Canada for a client, I've got a colleague in Canada that I work with regularly. I call her and she files it for me, and we have it all wrapped up pretty quickly, and she keeps me posted. That's it. It's very, very simple, and very widespread adoption. There's more countries that do Paris than do the PCT. The con, though, is that that attorney in Canada, I have to pay her too, and the client has to pay her. So we need local counsel and local expertise in each jurisdiction. Comparatively expensive as a result of that. But if you're only doing it for a couple of countries, that Canadian example is a real one. I filed in Canada for this client. He's not interested for this particular product in Europe and Asia and things like that. So it makes complete sense to do it this way. PCT would be on that one. Minimizing your patent risk. So let's talk about what you can do to avoid that nightmare scenario where you get a cease and desist letter, or I have clients that have gotten sued without any warning. It happens. There's a lot of money at stake here. So what can you do? One thing before you launch a product, we like to do freedom to operate, or FTO studies. And these can take on lots of different forms, but the general idea is that, you get an attorney and he goes out or she goes out and does a search of the prior art. And, I've got this concept, I've got this idea. You get somebody to do a search and find all the patents and published applications and whatever else they can find relevant to them. They give it back to me. I study it, I analyze all the results, and we write a report. We write an opinion. So the variations on this can be from a full-on legal opinion down to just kind of a quick oral opinion. There's lots of different ways that you can do it, but the idea is that you're getting someone to take a look at the prior art and you're getting a legal analysis done. And that can be helpful in litigation if you're ever sued. It can be helpful with investors, certainly. It can be helpful with insurance companies. There's lots of different reasons why you might want to do that. A great tool for mitigating risk. It happens to be, it can be expensive. Like having someone do the search and the analysis, can get well into the thousands of dollars. So it's a question of your risk tolerance. There are certainly some do-it-yourself resources for doing patent searching and patent studies. Google Patents is great. Google Patents is a little bit behind some of the other databases, some of the government databases, but it's the search front end is fantastic. SpaceNet is probably, I think, one of the best searching tools in the world. It's the European Union, the EPO's patent database. These are good for not doing a freedom to operate search, which requires some legal analysis, but they are good for just identifying patents that are out there. Taking a look and getting the landscape and just see, has someone come up with something similar? I've had clients come to me with an idea and I've been able to find it in Google Patents literally under 5 minutes. So, they could have saved themselves the trouble. So there's variations on that again of how much searching you want to do, and you do want to keep track of what you're searching, because you may be under an obligation to disclose your search results to a at some point, when you do the application. So keep an eye on that. We conduct novelty studies. So here, this pertains to, can I get a patent on my invention? Freedom to operate deals with can I make this product without being sued for patent infringement? The novelty study is, well, can I get a patent on it? The risks here are a lot lower because the investment in a patent application is modest compared to, a damage award for patent infringement. So this is the same kind of thing we do. We use these tools and we come up with an opinion on, can you get a patent on this? It tends to be much less expensive and much simpler. And this is one of the areas that you want to get professional help on this stuff. This is not, there are some resources where you can do some of the work yourself and get a start, but ultimately you want to call in an expert. One last caution about disclosing your invention, and this has to do with whether you're ever going to look into patenting it yourself. You want to be careful of disclosing your invention publicly before you file a patent application. And publicly means basically to anybody without a confidentiality obligation. It doesn't have to be from the mountaintop, but it can be, casual. It can be casual to an investor. That's a public disclosure if there's no NDA in place. You want to be very careful of that because a couple of reasons. One, a lot of patent systems, including the United States, are a first to file system. So whoever makes it to the patent office first wins the patent. Doesn't mean that someone can steal it from you and go and do it. I mean, they wouldn't have invented it, but you want to be careful to not have it out there circulating. But more importantly here, the US gives you a 1-year grace period after your first public disclosure to file an application. After that, you are time barred, we say. It's an absolute deadline. So that first public disclosure starts a 1-year clock ticking. More relevant to you guys is there's a lot of foreign jurisdictions where there is no grace period at all. Like Japan has a 6-month grace period, for example. Europe has 0 grace period. So you want to file before you make that public disclosure. It's very important and it's a not uncommon trap. So trademarks, we're going to spend a little bit less time because I think trademarks are deceptively complex, but I think the nuts and bolts are a little bit simpler. There's less nuance to it. Let's talk about the case. We talked before what a trademark is. A trademark is an indicator of source. It's something that tells people where the product or the service comes from. So what's fundamental to that? It has to be distinctive. Your trademark has to be distinctive and act as that source indicator. Distinctiveness comes in a couple of forms. One, you can't have a trademark that's confusingly similar to someone else's trademark. It's not distinctive then, right? That means having the same trademark as someone else for the same goods, similar trademarks for the same goods, the same trademark, similar goods, you get the idea. There's kind of a sliding scale, more or less, of likelihood of confusion. That's the standard for whether you can get a trademark in the United States. Is it confusingly similar to another? The second prong to distinctiveness is inherent distinctiveness. If your product, your trademark has a name that is just descriptive of the goods, well, then it lacks distinctiveness. If it's, a surname sometimes, if it's not, if it doesn't meet certain criteria, or if it just merely describes the goods, it's not distinctive. So let's talk about that, look at that as an example. This is in every intro to trademark class. There is this continuum of trademark distinctiveness. The best and strongest trademarks you can come up with, assuming that they are not similar to anyone else's. The best trademark you can come up with, the strongest, is something that they call fanciful. Exxon is a made-up word. Exxon is a great trademark for that reason. There's nothing about it that exists in language. It doesn't tell you anything. When you hear Exxon, you very immediately associate it with that company. Arbitrary trademarks are ones that here, Apple is a real word. Apple is a real thing, but we're applying it to computers with Apple Computer. So it's arbitrary. So it's not quite as powerful or distinctive as that made up term, but it's still pretty distinctive because that's unusual. The suggestive trademark, like Microsoft gives you it suggests a vague sense of software and computers and things like that. So not as distinctive as an arbitrary mark like Apple, but still it's unique enough that it's not dead on arrival with the trademark office. Now you get down to something descriptive like Windows. Like Windows, for Windows software at one point would certainly have been not registrable because it was not distinctive. Over time, you can get around that by showing that it's become distinctive in the public eye, but descriptive trademarks are typically dead on arrival. And then generic. Something like zipper is just generic, and you can't even get that public recognition to get you out of that. Trademark registration. This is the process where we formalize our rights in most countries. And you can use a trademark and you can have rights in a trademark. But then you go to, in the United States, you go to the federal government and register it, and it gives you enhanced rights. So it's optional in the United States, but it is very important and very advisable. It gives you a right of national priority in the United States, not just regional where you've used it. It puts others on notice of your rights because there's a big database of trademarks and people look at it all the time. It lets you sue in federal court here, and it lets you use that R in a circle, which gives, I suppose, some cachet in certain circumstances, but it's a powerful indicator. And it also lets you record the trademark with customs, and they will seize counterfeit goods if you have a registered trademark, which is, and it's actually pretty amazing that if you do that and go through the process, customs agents will send you pictures from like the port of Long Beach saying, hey, are these counterfeit batteries? And oh yeah, and then they'll seize them, and then you go to court and go through the whole process. But it's a pretty powerful weapon if that's the type of good that you're selling. Trademark coverage, it's very similar. Territorial, country by country, and 2 routes to international coverage. We've got direct filing under Paris, and this time instead of the PCT, we've got this Madrid Protocol. So with the Paris filing here, it's a 6-month window to file and claim your priority, not 12 months. You still need local counsel. It gets expensive still if you have that broad country base. If you're going in 20 countries, it's going to be expensive. There's something called the Madrid Protocol, which is analogous to the PCT. It gives you a single application system for obtaining trademark registrations and updating them. It's got 122 members last I looked, so it's a pretty widespread acceptance. It doesn't have the formalities necessarily and all the hoops of the PCT. It's much less expensive than individual Paris filings, country by country. But the downside to it is that you've got this centralized registration. With the centralized registration, you are vulnerable to a centralized attack. If there is some flaw or problem with the Madrid registration, all the different countries under that Madrid application fall with that centralized application. So it's vulnerable to a centralized attack. Just one point to note, you don't have that with a PCT. PCT doesn't have a centralized attack issue. PCT, once you go through the process and then you split off into individual countries. Here, you go through the process and you get a single unified registration. I think this, doing something like Madrid for patents has long been a dream of the patent world. I think Europe is slowly going towards a unified patent, but we don't have any patent system like this. It's a little bit different, but it's still very, very useful for diligence on the trademark side. Obviously, the same considerations. You don't want to get sued for infringement, and you want to make sure that you can actually use what you've developed. So pick strong trademarks. Don't pick trademarks that are too close to someone else or are overly descriptive or anything like that. Conduct your due diligence before you start using it, because I've had lots of clients who had to stop using a trademark after the horse is out of the barn. They've started working on their business and they have to go back and start over, which is frustrating, and you lose goodwill. Do it before you start using it. Same type of thing. We run clearance searches on the trademark side. They are much less complex than a patent search and tend to be a lot less expensive, well under $1,000 to do a clearance search and opinion. We look at, same thing, we go out, we hire a service, they go do a comprehensive search of trademarks and common law use, like websites, domains, business registrations, and things like that. We look through it and we give an opinion if the mark's clear or not clear. It can help you in certain instances with avoiding damages for willfulness and trademark infringement. If you can go and show it, hey, I did my homework before I use this, you're not going to get nailed for enhanced damages, as they say. And then the other thing is that, once you have a trademark registration, you want to be careful how you use it. You want to use it consistently as a trademark. You don't want to use it in a descriptive sense. You don't want to license it casually without the proper descriptions that give you control over that trademark. Definitely worth the same thing, getting some advice from the outset on how to maintain this right that you put some investment into. Here we are on the substance. I talked about us and what we do a little bit earlier. Pretty much handle anything related to IP. That's actually our new office. We moved a couple of weeks ago. We are, as you I'm sure know, like the COVID outbreak is a little bit significant in the United States. So I moved our office closer to home base, and so we don't have to commute by subway every day. So I'm actually pretty excited about the new space, and happy to give this back to James, and you're going to coordinate our questions.
First of all, David, thank you so much. This has been really informative. I appreciate it, and taking the time out.
Information. I appreciate. Yeah, I know it's a lot of information in there that I jammed in there, but I figure people will take the slides with them. They can go back and refer to that. So I'd rather be over inclusive than under. So thanks everyone for your attention for that whole time.
The first question is coming from Marcus. What are your suggestions in regards to apps? Is it worth protecting them considering how fast they get stale and replaced?
Because this comes up a lot, because so if you're going to protect, if you're looking at a patent application in the United States could easily take 2 years and will probably take closer to 3. That's not aligned with the business life cycle for an app necessarily. So there's other ways you can, design patents are an option, copyright on the user interface and a lot of the elements within the visual elements within the app. But unless there's something really novel going on, I think apps are generally pretty hard to protect on themselves, the functional components of it. So I'd go, visual and ornamental is what I often advise. It's a shorter window and you have a greater likelihood of it.
Excellent. So I actually have a question from past experience in a former life. What happens if an Estonian entrepreneur files something locally here? Are they still protected under the Paris Agreement when they go and register in the US? Or is it possible that if somebody in the US becomes aware of their invention or their mark and chooses to formally file it directly within the US, even during that year grace period, who would get priority in that scenario?
The Estonian wins there. So if you've got, provided that the Estonian entrepreneur actually goes and perfects that filing in the United States, it's retroactive to the Estonian filing date. So you would beat them.
Okay, and if they do it outside of that 1 year buffer period in the US, would they still come out as the winner in terms of priority, or would the American patent then take priority and precedent?
Yeah, who does it outside the 1 year? If the Estonian misses that 1 year filing date in the United States to make their claim, what would then happen is the Americans still wouldn't be able to get the filing, probably still wouldn't be, it depends on the exact dates, but the American would probably still have trouble getting the application through because the Estonian application is now potentially prior art to the American application, assuming it's published first and some things like that. But it's not exact. It depends, like I said, on the dates. But that's one possibility. But I think the moral there is just to go and like do the U.S. filing. If there's certain markets in the world that are pretty significant, and we consume a lot of stuff here, so it's always wise to file here as well.
Yes. So I mean, so that then is another question. Is it worth going through the international protocols for filing, whether you're filing a patent or a trademark, or maybe it's different depending, or is it always better to still file directly in the U.S., even if you're going the international route for most other markets?
Filing directly in the U.S., you are using the Paris Convention. Like that treaty gives you that ability. So just by filing in the U.S., that's the Paris route. The PCT, you go through all the additional steps of the PCT, but that's certainly, yes, you could file directly in the United States, but it would still be under the Paris Accord.
Understood. Got it. I want to open the floor up to the group of attendees who are here with us. If anybody has any other questions, we've answered everything that's in the questions area. But if you have any questions that you'd like to ask David while he is live and with us, please do enter them into the chat now, and we can address them. And if the chat is quiet, then I am going to assume that all your questions have already been answered. And so with that, I mean, if there are any, if I can ask you to share with everyone, David, kind of some parting words of wisdom for anyone who is currently either on this journey or about to embark on this process, what's the one thing that you would encourage them to do that they might not have thought about?
You can do a lot of this if you are developing an idea and you want to monetize it or build a company around it or whatever it is. You want to formalizing your intellectual property, turning it from the concept stage to some sort of legal right. It's super beneficial when it comes to dealing with venture capitalists and investors and everything else. You want to do that. But that doesn't mean you have to just jump off and start spending thousands and thousands of dollars right away. When you do, there are certain things like filing a patent application is not something that, should be done. The trademark application, it's the same thing. It's deceptively complex. However, there's a lot of upfront work, and you can educate yourself on when you've got this presentation. There's lots of resources available from the different patent offices. You can learn a lot about it and do a lot of your own homework now in a way that was, it's more possible now than it ever was. So you can, participate in the process and do your homework, but then sometimes you need to enlist an expert. Oh, we got a question in the chat.
Yes, another one. So how fast can I obtain a search report from the U.S. Patent and Trademark Office when putting through a patent application?
Well, so to immediately answer your question, about 14 months, plus or minus. That's an average across all technologies and all examiners. What happens when you file an application in the United States is that it goes into a queue. There's no, it's first come, first serve unless you prioritize it. And an examiner will be assigned by their algorithm. An examiner will be assigned to it at some point, and then the examiner will get to it when it's time for him to get to it. Basically, that there's a backlog of 500,000 plus applications in the United States Patent Office right now, and it takes a while. So the first thing the examiner is going to do is that search and issue an office action. That more often than not rejects your application, but it's a starting point for negotiation. That process takes about it takes a little over a year to get that first office action, typically.
Excellent, thank you. And from Alexei, what is the general cost for trademark registration end to end? If you can give us both, what are the raw costs if you were to attempt to do it yourself, which I don't recommend, and what are the average costs when working with counsel, somebody like you?
In the United States, we charge per class of goods and services, and the universe of everything one might sell is divided into like 40 or something classes. So assuming you have a single class of goods, it falls into one bucket out of those 40. It would be a $225 to $275 charge from the United States government, from the Patent and Trademark Office for the application. There's no issue fee. There's no fees along the way other than that I can think of. If you get an rejection, there's no fee associated with responding. If you enlist an attorney, obviously they're going to set up the application. They're going to talk to you about the goods and services and make sure it's in condition to get through. There's, some other benefits to that, but there you're probably looking at, closer to $1,000 total to get that application through. Maybe a little bit more. It depends on how much resistance you get from the trademark office. But budgeting $1,000 is usually enough for a single class.
Excellent. And so with that, I will give everyone an opportunity for any last questions, not relating to the mic issues that we've been having. I apologize. It seems that there has been a bandwidth issue, and that has been causing some muffling of the sound. But I hope that everything was understandable for everyone. And if there is... we have one more question. Regarding a patent application, what sort of services do you provide? Do you write the applications, do the drawings? Like, what is involved when you're servicing a client?
It really depends on the client, but on the broadest one, client comes in, we talk about what the idea is, the concept, and we do a search, we narrow the concept down, we write the application with their assistance. We have somebody that does the drawings professionally. It's the most efficient way to do it is to send them out. But yes, we'll do the drawings, everything like start to finish.
Perfect. David, thank you so much. It has been a pleasure to have you.
My pleasure.
And I hope that everyone who's joining and listening today had some valuable takeaways. I know that I did, and some things that I had previously thought about the process have been clarified, so very helpful for me as well. And anybody who is listening, please feel free to reach out to David for any follow-on questions that you might have that maybe you didn't think of in the moment. Please look to him as a resource and a source of information. And I wish everyone a very good evening. And thank you so much for joining us. Thank you again, David.
Appreciate it. Take care.
Bye, everyone.